Okay, now let's see Schedule 2. So Schedule 2 gives a whole list of transactions which are either to be regarded as supply of goods or regarded as supply of services. Now you'll ask me that why the reason, what is the reason behind this Schedule 2? It's simple. In the earlier times, in the times of excise duty and service tax and VAT, that is pre-GST era, there used to be a lot of litigations. Like suppose if my transaction was covered by service tax, I would go and prove in the court of law that this is not a service, it is goods. Hence I should be covered by excise duty or maybe VAT and not service tax. And vice versa. If somebody would want to avoid excise duty, he would go in the court of law and prove that his is not goods but service. So he should be covered by service tax and not excise duty. So these type of litigations existed in the pre-GST era. Now to avoid such litigations in the GST era, they have what the government's done, that they know that where the litigation lies, which type of transactions are of ambiguous nature. So they have defined them and clarified in this schedule whether they are to be considered as goods or as services. Understood? So therefore, let's see. So the schedule is made under subsection 1A that we have seen in section 7, which says that activities or transactions to be treated as supply of goods or supply of services as referred to in schedule 2. So let's see. And what you have to do here in the schedule is to remember all these points. Okay, not much to be explained, but to be remembered. So first is transfer of title. First point is any transfer of title in goods means ownership is supply of goods. Obviously, if ownership itself is transferred, then it will be called as goods, because goods ownership gets transferred. So write down there, transfer of ownership. Like I have this pen, so if I transfer it to you in the sense that now you become the title holder, then obviously this thing will be called as goods, right? But right now I am teaching you. Can teaching be transferred? Can I transfer title of teaching? No, that cannot be done. So therefore teaching is a service, right? So wherever the ownership is there and ownership can be transferred, that will be called as goods. So it says transfer of title in goods is supply of goods. But then there is an example given, very interesting example, that when the goods are stolen, they are lost, they are stolen by someone, can you say that the title has passed on to the thief or the burglar? No, the title doesn't pass on to the burglar. So if the goods are stolen, then it cannot be considered as goods, or rather supply of goods. But if you have claimed insurance, if you have got these goods insured and you claim insurance compensation, then yes, then it will be regarded as transfer of goods, because the title passes on to the insurance company, right? So that is given there. When the goods are stolen, the title shall pass to insurance company, but this would happen only if you have insured the goods, right? Good. So then it will be called a supply of goods. Then another point, any transfer of right in goods. Now see, this is the difference. Title and one of the rights. So title means ownership. If the ownership is transferred, that will be called as goods. But if only one of the rights is transferred, that is, for example, right to use, right to enjoy, enjoyment rights, right to occupy, if only these are transferred and not the title itself, then it will be called as a service. Okay, Like renting out is a service. I've let out my goods to you for some time on leave, license, rental agreements, then that will be called as service and not goods. Okay, so that is a simple point. So it says, or of undivided share in goods without the transfer of title. Without the transfer of title thereof is a supply of service. Examples are given: rentals, operating leases, etc. Operating leases where there is no intention to transfer the title. Finance lease means where there is intention to transfer the title. Then any transfer of title in goods under an agreement which stipulates that property in goods shall pass at a future date upon payment of full consideration as agreed is also supply of goods. Very simple. Hire purchase, installment schemes, they will be called as goods. Okay, simple one. So what it means is, if we compare A with C, A is a case where title is transferred immediately. C is the case where transfer will take place on a future date. Still, it will be called as supply of goods, because ultimately the title transfer is involved, whether it is involved right away or is involved at a future date. And a small chart is also given there, which you can of course go through. There's nothing big in that. So that was the first point. Second point says land and building. Second point is specifically related to land and building. It says any lease, tenancy, easement, license, different words are there, but they all mean rental, different kinds of rentals. Like lease is a long-term thing, tenancy we normally call tenant, easement, license, leave and license agreement. To occupy land, first point is regarding land, is supply of service. Is supply of service. So renting of land, if I have a land and I am letting it out to somebody for say parking purposes or any purpose in my city, you are of course knowledgeable enough, you know that I own a lot of land in New Delhi, that whole Parliament area from India Gate to Parliament House and President's Palace, what do you call as a Parliament House, that whole area is owned by me, which I have leased to the government for different purposes. So that lease of land to the government will be service, obviously. Examples are given like for circus, entertainment, parking, etc., etc. Any kind of business use. Then any lease or letting out of building, second point is regarding building, including a commercial, industrial or residential complex for business or commerce, either wholly or partly, is a supply of service. So it is same as land, only difference is that here it is given for business or commerce. This is important point. A building let out for business and commerce is taxable and it will be called a service. But if it is let out for residential use, like I have a flat and I let it out to you for residence, there is no GST. It will not be considered as supply. Okay. So transfer of a residential house for residential purpose, like letting out of flats, is not a taxable service. So it is not considered as supply. But for business and commerce, yes, it is taxable. So that point you have to remember. So it says leasing of building for commercial purposes means the same for business and commerce, shall amount to supply of service. The next is treatment or process. You can write down there job work. This is called as job work. Means somebody sends his goods to me for some kind of work to be done on it. Maybe some repair is to be done, or some other kind of testing is to be done, or some features are to be added, some polishing is to be done, something has to be done on the goods which are supplied by another person. so that will also be called as service. Okay, so job work will be treated as supply of service. Given there, job work shall be treated as supply of service. And the definition goes like this: any treatment or process which is applied to another person's goods is a supply of service. Then transfer of business assets, next one. Where goods forming part of the assets of a business are transferred or disposed of by or under the directions of the person carrying on the business so as no longer to form part of those assets, means permanently transferred, whether or not for consideration, such transfer or disposal is a supply of goods by the person. Another very simple point, that if I've got goods which are forming part of my assets of my business, okay, they are not personal, they are business assets, are transferred or disposed of, whether or not for a consideration, means whether I've taken consideration or not is immaterial. If they are part of my business and I am disposing them off, I am transferring them off, who is doing it? The owner of the business himself, or on his direction some other person is doing it, then it will be called as supply of goods. Okay, like expired products disposed of by the company, or disposal of goods destroyed by fire. So fire has damaged the goods and we are now disposing of those damaged goods. All these examples. So as no longer to form part of those assets, means it will result in depletion of assets. Then that depletion will be called as supply of goods. Then whereby or under the direction of a person carrying on business, goods held or used for the purpose of business are put to any private use. So this is regarding use, use, not transfer. So if I am having, say for example, my shop, and the shop is to sell televisions. It's a very big shop selling all brands of TVs. Now because of the World Cup, I have shifted one TV from my shop to my home for watching World Cup matches and Wimbledon matches and other sports and so on and so forth. When I'm not there, the people in my house watch the serials also, the Saas Bahu sagas, whatever. It is converted to private use. Business asset is getting converted into private use. This will be called as supply of goods. Okay, put to any private use, or are used or made available to any person for use. So it can be made available to any person also, like house people and so on and so forth, friends, for any purpose other than a purpose of business, means business assets converted into private use, whether or not for a consideration. Again, see, whether or not for a consideration. Obviously, when I am shifting my own television from my shop to my house, will I charge consideration for that? No. Or if I am giving it to use for to any family member, will I charge consideration? No. Or to a friend? No. Of course. Still, the usage or making available of such goods is a supply of service. Sorry, I told goods. It's not goods, it is service. So if I convert my, because ownership is not transferred now, only the use is transferred, hence it will be called as service. Okay, like example is given there, that a dealer of Maruti Suzuki car used one of the cars, which is Desire, for his personal use, or gave it to his daughter for use. It will be called a supply of service. Why service? Because only use is given, not ownership. Okay, but if you gift assets to your family members, if I gift car to my daughter, then that will be called as supply of goods. Okay, and if I only give the use, then it is service. Then C point says that where any person ceases to be a taxable person. Ceases to be a taxable person. Interesting one. I've got a lot of stock in hand and I cease to be a taxable person. Now this may happen when I cancel my registration. Why do I cancel my registration? That I'll tell you later on when we'll go to the chapter of registration. There are situations when we have to cancel our registration, or we get complete exemption for our goods. Our goods become exempt, hence we are not liable to pay tax anymore. So what happens in such cases? So where a person ceases to be a taxable person, ceases means stops. Okay. Any goods forming part of the assets means stock in trade, the stock which I possess. Okay. Stock of any business carried on by him shall be deemed to be supplied by him. Deemed to be supplied. So whatever stock remains with me on the day I cease to be a taxable person is deemed to have been transferred, deemed to have been supplied. In the course of furtherance of business, immediately before he ceases to be the taxable person. Means whatever stock I possess at that point of time, I have to pay the duty on that stock, right? I have to pay the tax on that stock, unless there are two exceptions. One, the business is transferred as a going concern to another person. If I transfer my business as a going concern to you, for example, I'm selling off my business to you, then you will be taxable now. When you supply these goods later on, you will be taxable. So in that case, I will not be taxed. So I can transfer my complete stock to you free of any GST. Okay, there will be no GST imposed, and then later on when you will sell the goods from the shop, you will be liable to pay GST. Okay. So if I shut down my business, then my stock is deemed to be supplied. But if I transfer my business to you as a going concern, then I don't have to pay any GST. So one is transferred as a going concern. Secondly, it is being carried on by a personal representative who is deemed to be a taxable person. Simple. I appoint a personal representative like a trustee to run my business. So then he will pay tax on actual supply. So when I shift my business to a personal representative, at that point of time there will be no tax. And the example is given. There are different ways in which you cease to be a taxable person. So this is one of the examples. Sonu and Sons, I think the son was called as Sonu, but later on he also has sons, so it was called as Sonu and Sons. Anyways, that was a joke. Leave it. Contravenes the provisions of GST, and for this contravention, proper officer passed an order to cancel the registration. This can also happen. The officer cancels your registration. So you cease to be a taxable person. So what you have to do? You have to pay tax on the stock that you possess at that point of time. So whatever stock you possess on the immediately preceding day will be liable to tax. Simple. Then in point number 5, they have given a lot of points which are to be considered as supply of services. So all these points that we'll see are called as supply of services, and these were mainly the controversial issues under service tax law. So they are accommodated here in the GST law. Government, to avoid controversies, have prescribed in the initial stage itself that these are called as services. Don't ask any question later on. Number 1, renting of immovable property. Renting of immovable property, whether land or building, will be called a service. Okay. Number 2, construction. This is an interesting one which will have a lot of implications later on also, and there are a few amendments also that have come from April 2019 in construction industry, but some of them are applicable and some of them are not applicable from exam point of view. That we'll discuss in later chapters. So this is construction of a complex. Complex means multiple flat scheme multiple, it can be commercial complex, it can be residential complex also, it can be a mixed complex also. Then building, a simple building, construction of a building. Civil structure, any kind of a civil structure, which can include a factory building, anything, or a part thereof. Means you can be constructing the whole, or you can be constructing a part of it, including a complex or building intended for sale, including a complex which is intended for sale to the buyer, wholly or partly, except where the entire consideration, means except where 100% consideration has been received after issuance of completion certificate wherever required by the competent authority, or after its first occupation, whichever is earlier. This is a very interesting point, and this you should understand from this stage itself. Later on we'll see a lot of points on this, so let me explain you what this means. Okay, let's see. Now in construction I'll explain you a lot of things. Some of them are applicable right now, some of them are not applicable, but they will come into picture later on. So you must have an overall view of this whole industry, how it operates. So I'll explain you different examples. One is that there is a owner of land. Okay, he comes to what we call him, construction contractor. Yes, so he comes to a contractor, okay, and says that, look, I have a land, this is my land, and I want to construct a beautiful house on it where myself and my wife will stay, and kids and all. So he wants to construct a house on his land. So he comes to a contractor and says that, can you do it? Contractor says, yes, I'm there for doing it, that's my business, I'll do it. So he says, I'll charge, say for example, rupees 3000 per square feet as construction cost. Okay, or a lump sum. It can be on a per square feet basis, which is the normal industry, or he can say, he can quote a lump sum amount of say rupees 80 lakhs. So after the map is finalized and he knows that how much work is to be done, he says that, okay, I'll do it for 80 lakhs. Just give me 80 lakhs and you will get your house ready in 6 months. Or he says that, okay, I'll charge 3000 rupees per square feet of construction. Whatever the case may be, lump sum or per square feet, these amounts are purely, this is a pure construction service. What is a pure construction? Where only construction service is involved, land is not involved. Means the contractor doesn't own the land, he is not transferring any land. Okay, land already belongs to the user, the owner, and the contractor is purely giving a construction service. Okay, so these amounts are fully taxable, under GST. Okay, whatever the rate is, though we don't have to study the rates of tax, there are different rates, but whatever the rate may be, it will be chargeable. So this is one thing. Now second is an interesting one, that there is owner of land. He comes to again, you can call him a contractor, you can call him a builder, you can call him whatever you want, but from tax point of view, from law point of view, we'll call him as promoter. So he promotes a scheme. These are big schemes. So the builder even sometimes doesn't own the land. The owner of land comes to him and says that, okay, I'll give you development rights. So he owns the land. The person A owns the land. He gives to B the development rights. So he transfers the development rights Okay, later on in our course of discussion we'll see that this transfer of development rights is also a service. This is also a service which is chargeable to tax. Okay, but how, that we'll discuss later on sometime, not right now, because you'll not understand many things right now. Okay, but he transfers the development rights, or the FSI, sometimes it is also called as the floor space index, FSI. He transfers the FSI or development rights to the builder to construct a building and sell it to the customers. So the builder is going to construct the scheme, the whole scheme. He will be constructs the scheme, or what we call here as the complex, residential, commercial, so on and so forth, for sale. After doing this, he will sell it. What he is going to do, he will sell the same. Okay, he will sell the same. So when he sells it later on, will this be taxable? Making and selling, will this be taxable? So answer is yes and no. So this taxability we'll discuss right now. So just put an A there, or if you have a bigger page there, you can write below it itself. I'll write it here. So here what happens is that this B is selling to customers, okay, the flat owners. So these guys are going to become the flat owners. So when B transfers this building or the flats to the customers, the question arises, will this be called a supply? So let me tell you. If B, now let us take there are two things involved here. I'll explain in a simple way, not the complex way. So two things are involved. One is that when is this what we can say construction getting completed? Okay, let me go the long way so that you understand it fully. Okay, so now what B does is that he makes a scheme on paper. First of all, the land is there. Now he'll make a scheme on paper, get the building plan made by the architect, and then we'll give it to the municipal corporation for approval. It will take a long time. Around 30-40 approvals are required from different organizations of the government. First the planning department, then the sanitation department, then the electricity department, then water department, then it will go to pollution department, then it will go to fire department for fire NOC, and so on and so forth. There are more than 30-40 approvals required, which takes long time and lot of you understand. So while this scheme is in this whole process, we launch this scheme. What we do, we launch the scheme. So we make very good images, Photoshop images which shows big buildings getting constructed, lot of buildings, and the swimming pool and the gymnasium and this and that, lot of things will show on those big brochures, and call public. We'll put lot of holdings in the city and call public to invite public to come and purchase our flats. Now, is the scheme ready? No. Has even the first axe being the earth breaking ceremony done? No, nothing is done. Right now all the proposals are pending with the municipal departments and other government departments, but we have launched the scheme, and we'll start taking bookings from the prospective buyers. Okay, so what we'll do, we'll launch the scheme, we'll take a small deposit, what we call as the booking amount, and then we'll fix a schedule of payment depending upon the stages of construction. That when the plinth will be drawn, you'll have to pay 10% more. Right now you just pay the booking amount. Then when the plinth is ready, you pay 10%. Then first floor is ready, you pay 10%. So if total 15 floors are involved, so we'll collect money slowly and steadily from all these flat owners and keep constructing. And finally, when the building is completely ready, we'll make an application to the municipal authorities or whatever authority is there in our locality, in our area, take certificate, completion certificate from them that the building is complete in full. For that, first our architect will make a report, submit it to the NMC. NMC department means municipal corporation departments will visit the premises, they will check everything, they will verify everything, and after proper verification they will give a completion certificate that the building is completed as on this date, certified. Or in some places, if the if the completion certificates are not required, because this is as per the local laws, so if the local laws do not require such thing, then there is an occupation certificate, that when we grant occupation to our flat owners, we make occupation letter that you are given occupation, and he signs it and returns one copy back to us. So that will be called as the occupation. So the occupation will be considered as if the building is completed, hence the occupation is transferred. Okay, so this is one date to be considered, the completion date of the building, either the completion certificate or occupation, whichever is earlier, that is written there, whichever is earlier we'll take. And compare this with when did we receive the consideration from these prospective buyers. Means basically, when did I sell the flats to them? So if I sell off the flats to you in the construction phase itself, and the occupation is later on, construction completion is later on, okay, or it can be reverse. I have completed the whole building with my own money, I did not sell any flat to anyone, I completed it with my own investments, got the occupation or completion certificate from the departments, and then I sell these flats to people. So there can be two alternatives. First you complete the whole project, then you sell, or you sell off and you keep completing it. Now the question is, in which case the GST is applicable. So GST is applicable when you sell the flats first, means receive payment in full or part, and then there is completion or occupation. So completion or occupation comes later on. So in this case, when you sell off the building first and then you complete it or you give occupation, then this is taxable. It is called as construction service, and the amount that you take for the flat will be fully taxable. So if you sell the flat for 2 crores, that 2 crores is chargeable to GST. Okay. Now the question is that why this distinguishment? See, it's very simple. Even though you are selling it, but the sale takes place when the building is not there, it is not existing, right? Building is not existing today. So there is an agreement to sell entered into between me and the buyers. I am the builder, promoter, and then I keep constructing it. So point is that for whom am I constructing? For myself or for you, the buyers? For you, because I have already sold the building to you. So my construction is for you, not for myself. So therefore I am giving a service to you. Okay, so therefore this is taxable as a service. This will be taxable. This whole amount that I receive from the customer will be taxable. But if I complete the building for myself, I am the owner of the building, I am completing it, I complete the full construction. So for whom am I constructing? Myself. So is it a service to anyone? No. Later on, when the building is ready with completion certificate, I sell it to somebody. So the sale takes place when the building is already complete. So in that case, I am not giving service to anyone. It is a sale of building, and sale of building is not taxable because I am not using it as a factory building or something. So sale of building, completed building, is not liable for GST. Understood? So sale of a completed building is not liable for GST. And resales also, like you already stay in a flat, you are selling your flat tomorrow. Is it liable to GST? No. It is liable for some stamp duties which are collected by the government, but not GST. So understood? So we write down two things. First and second. So if you sell first and then completion certificate or the occupation certificate comes, then it is a supply of service. But if the completion certificate or occupation is first and then you sell, then not taxable. Not taxable at all. Understood? So it's very simple. Now when you sell it first, sell means here when you receive the money, because otherwise agreement to sell can be made by people backdated also. Just to get exemption or whatever, they can enter into a backdated agreement also. We get backdated stamp papers and all. So government can be fooled there. So government says we will not depend upon your agreement date by itself, but we'll also see when did you receive the payment, because and payment also through bank. So did you receive any payment through bank which you can show? So that is to be seen. Okay. So that is given there. See again. Construction. So what is the name of the service? Construction service. So construction is the service of what? Complex building, civil structure or a part thereof. So first thing is simple, construction of complex. So if I don't own the land, if you own the land, you give me a contract to construct, I give you construction service, that is taxable. That is a pure construction service, fully taxable. Then it says including a complex or building intended for sale. So this is the second point. So there are 2 points in this. First is simple construction of building, complex, etc. That is always taxable. Second is including complex or building intended for sale. So though we have intended it for sale to a buyer wholly or partly, except where entire consideration has been received after issuance of completion certificate. So this is the exception. If entire means 100% consideration is received after completion certificate or occupation, whichever is earlier, then in that case it will not be taxable. It will not be called as a construction service, because construction is done for yourself. You are the owner, you are constructing a building for yourself till the time of completion of construction. So in that case, construction is finished. After construction is finished, the service ends, then I sell. So then that sale will be a sale and not service. Understood? And sale of building is by itself not taxable in GST. It is taxable to stamp duty. Got it? So I'll explain one more point here. So what we'll do here is that we if this is my completion certificate or the occupation whichever is earlier, okay, 13th of May 2019 for example, and 50% consideration was say received on 19th April 19, okay, and 50% received afterwards on 30th June 19. So then the question is that how much is taxable? Only this 50%, the first amount is taxable, or both, complete amount is taxable? So answer is complete amount taxable. So both these amounts, 50% and 50%, are taxable. It will be called a supply of service, and both the amounts, the amount received before completion as well as the part amount received after completion, both will be taxable. But if the completion or occupation is on 13th May 19, an entire 100% consideration received on 30th June 19, then it is not taxable at all. Okay, understood? Now absolutely crystal clear? Very good. So come back, and then a few explanations are given. That is all simple, nothing to be read there. Competent authority. Who is the competent authority to give the completion certificate? You don't have to worry about it, that the government will worry about it. Just read it once. The architect or the chief engineer, chartered engineer, and so on and so forth. Nothing use. And construction includes additions, alterations, replacements, remodeling of any existing civil structure. Construction includes not only the original construction but also changes, additions, alterations, replacements, remodeling, that will also be included. Fine, no problems. Understood? Very good. The next one is C. Temporary. Temporary means for the time being. Transfer or permitting use or enjoyment of an intellectual property right. Very simple example. If I own a trademark or a patent or a copyright and I give it to somebody for temporary use, like I write a book, I own the copyright and I am giving it to publisher to publish it. So whatever royalty I will receive is liable to GST. Everyone knows, and it will be called as service. Okay, so giving use or enjoyment of a copyright, trademark, license, etc. will be called as service. All simple examples. Then next is development, design, programming. The software industry by itself is a service. Everyone knows it. Everyone knows it. Development, design, programming, customization, adaptation, upgradation, enhancement, implementation of IT software. And then E point says agreeing to obligation to refrain from an act or to tolerate an act or a situation or do an act. This is the same thing we have discussed earlier also. Refrain from an act. I gave you a lot of examples that I take money from you for not teaching one batch or two batches just because your wife has started teaching, so you pay me money not to take a batch so that she gets students, right? So the money that you pay me will be called as supply of service. Non-compete fees basically, or to tolerate an act or situation or to do an act. Refrain as well as to do. Either I should not do something, or I should do something, or I should tolerate something without arguing with you, without deliberations. So all these points are there. And basically in industry it is called as non-compete. Then transfer of right to use any goods for any purpose for cash, deferred payment or valuable consideration, like renting of coffee machine, generator, etc., projectors, and so many other things that are there. Right to use. Right to use is always a service. This is very simple logic. And then definition of services is also given. It means anything other than goods. We had seen this in the definition chapter also, but just read once more. Anything other than goods, money and securities. Other than goods, money and securities. These are common words. Other than goods, money and security, but including activities relating to use of money or its conversion. We had discussed this, conversion into cash from one currency form denomination to another. That is, foreign exchange conversions is a taxable service. And for services also, facilitating or arranging transactions in securities is a taxable service. Like brokership is a taxable service. So that was around, regarding service. Then 6th point is regarding composite supply. What it says that the following composite supplies means where there is a combination of goods plus service. Okay, so it says shall be taken as supply of service. So even though the goods are involved, but it will be taken as supply of service. In which cases, number one, work contract. In case of work contract is where I take some goods, means there is some material involved. I will mold that material into something else and give it to you. For example, I bring wood and upholstery and make a sofa set for you. So I am a carpenter. I'll make a sofa set for you. So while making a sofa set, it will also involve the use of materials. Okay, so raw materials would be wood, upholstery, etc., nails, screws, etc. So these are all goods. So for example, I use rupees 1 lakh worth of material, make the sofa set, and I charge 1,50,000 from you. So that whole 1,50,000 will be for supply of service. We will not have to divide the value into goods and service. Remember this point. In earlier times, in the old excise and service tax regime, we had to divide the value in work contract. Part of the value was considered for goods and part of the value for service. And the part which was for goods, you had to charge VAT and excise duties on that, and the part which was for value of service, you had to charge service tax on that. So in old times, the work contract value had to be divided, but now in GST regime they have said that don't divide it. Whatever is the total value, including the value of materials and service, it will be considered as service only. It will be considered fully as service. Okay, so that is the first point, work contract. So carpenter has to charge GST as if he is supplying service on full value. And secondly, supply by way of interesting. Write down there, then you don't have to read. Restaurants. In restaurant, what happens is that they cook food. Food is again goods, so they'll bring a lot of goods which can be veg, non-veg, etc., and tinned food and all. So that is goods. Then they will pour it into a container, cook something out of it, and serve it to the client, the customer who is sitting on the table. So when, say for example, I charge 350 rupees for paneer butter masala, out of that 350, 100 rupees might be the value of ingredients, right? 100 rupees is the value of ingredients, that is goods, and the balance for cooking and supplying. Okay, and the profit margin. So in food, the profit margin is around 200%. Like if I'm charging 300 rupees for a dish, my actual costs are 100 rupees. Yeah, it will be 100, and then I'm charging 200 rupees profit, so I'm charging 300 rupees from the customer. Still, do we have to divide the values? Then what is the value of ingredients and what is the value of service? No. The complete thing, full 300 rupees, will be considered as for supply of service only, no goods. So in work contract also and in restaurant service also, nothing will be considered as goods. Complete amount will be considered as for supply of service only. And examples are given, very simple examples. And in restaurant and outdoor catering also, any kind of food supply, where a person is supplying food and beverages, excluding that liquor, because liquor is out of GST, but other beverages are included, cold drinks are included. Then next is point number 7, supply of goods, pure goods. So it says the following shall be treated as supply of goods, namely supply of goods by an unincorporated association or body of persons to its members for cash, deferred payment, or any other valuable consideration. This is what we can say AOP or BOI, which we have established. It supplies the goods to its members only. Like for example, a consumer cooperative, they buy the consumer goods on bulk and supply it to their members only. Still, it will be considered as supply of goods and liable to tax. Means this, I think I discussed this point earlier also. Principle of mutuality is not applicable in GST, right? This is based upon principle of mutuality concept. Mutuality concept applies in income tax, and it says that nobody can make income by dealing with himself. Now in this case, as this is an unincorporated AOP, it doesn't have a separate legal entity. Means this AOP BOI and the members are considered as one and the same. They are not two different persons, they are one person, because AOP is not a separate incorporated body. It's not a company. Company gets a separate legal entity, but this is unincorporated, so it doesn't have a separate legal entity, right? So AOP and members are one and the same. They are one. So if they are one, can there be a supply? A question may arise now. Is that a supply? Because they are one. They are not two different persons. So government has written, yes, it will be considered as supply of goods and liable to GST. So principle of mutuality, that they are mutual entity, does not apply in GST, but it applies in income tax. In income tax, principle of mutuality applies. Nobody can make income by dealing with oneself. So AOP, consumer cooperatives, are not liable to income tax because they earn income from their members only, and the income is also for the members only. So it is not liable to income tax, but they are liable to GST. Okay. So it's like that. And then the goods and actionable claim is defined, which is of no use. Just leave it. So that was Schedule 2. And then we'll also go to the Schedule 3 also. We'll cover it. Transactions which are neither considered a supply of goods nor supply of service. Means they are not to be considered as supply at all. And no supply means no levy. No supply means no levy of tax on the following goods or services. Let's see. Means transactions. So they are given in Schedule 3, which we call as negative list, right? And subsection 2 deals with this. So let's see. Number 1, service by an employee to an employer in the course of employment. This I told you in the last lecture itself, that whatever service is given by employees to their employers are not liable to GST. Means there is no GST on salary. Simple. Okay. Second, services by any court, which can be district court, high court or supreme court, or tribunal. Tribunals like income tax appellate tribunal. GST itself also has a tribunal, which we called as the Central Board of Indirect Tax, and GST is there, but the tribunal is called as the appellate tribunal. We'll see in the chapter of appeals. It is called as appellate tribunal in GST laws. In customs also there is appellate tribunal, which is same as GST. Then in various other laws there are tribunals. Okay. So the services which are given by these courts will include your district court, high court, supreme court, and the tribunals which are set up under various laws. When you file a case there, you have to pay the fees. Case filing fees is there. On these fees, there will be no GST. Okay. Then third point is very interesting one. functions performed by our great member of parliaments, MLAs. MLAs means state legislature members. Then members of panchayat, members of municipalities and other local authorities. So whatever amount they receive for their services is not liable to GST. Now this we have known for years together, for hundreds of years, that these members of parliament and all, they don't give any kind of service, right? Now they have written it in the law itself that they don't give any service. Whatever they do cannot be considered as service. Then duties performed by a person. So basically what it means is that whatever amount the MPs and MLAs receive, or the panchayat members or other municipal members or local authorities, whatever amount they receive for the work that they do will not be liable to GST. Then duties performed by persons who hold any post in pursuance of provisions of constitution in that capacity, means constitutional authorities like Central Vigilance Commissioner or Election Commissioner or judges of court, High Court, Supreme Court, judges and all. These people do not give any service, means whatever fees they receive is not liable to GST. Then duties performed by any person as a chairperson or a member or a director in a body established under the central, state government or local authority, not deemed as an employee. So they are not employees, but they are committee members. Various laws have committees, like we have committee in indirect tax, that is the board itself, CBIC. Then you have CBDT in income tax. Then you have Competition Commission in Competition Act. So there are chairpersons, they are members of these boards and authorities, right? Now they are not employees, they are government appointed members on these boards and authorities, but they are paid fees, or you can say salary or fees, whatever they are paid. That will also be completely exempt from GST. Okay. Then services of funeral, burial, crematorium, mortuary, including transportation of the deceased. Funeral services, whatever services are required there, supply of wood, supply of what we call as the coffins, then digging of graveyard, the grave itself, and so on and so forth. All the services including mortuary and transportation of deceased, the ambulance and all which will be used, all exempt. Then sale of land and sale of building, except that under construction. So just now we saw in schedule 2, I told you that sale of constructed property is not liable, but under construction sale and then finishing it is liable to GST, right? So it will be called as the service. But sale of land or building which is already completed is not taxable. So that is given here, sale of land and sale of building. Exception is the one which is under construction, which is given in that schedule 2. Then actionable claims other than lottery, betting and gambling. So lottery, betting and gambling, these three are taxable. Apart from these three, all other kinds of actionable claims which give you right to receive money are exempt. Then supply of goods from a place in a non-taxable territory to another place in the non-taxable territory without such goods entering India. Interesting. Supply of goods from a place in a non-taxable territory to another place in non-taxable territory without goods entering India. Means there is a sale taking place. I am Farooq Haq. I am sitting in India. Farooq Haq is sitting in India, but he is supplying goods, okay, from New York to Washington. I've got a shop in New York, a jewelry shop, Modi shop, Nirav Modi. So we are named as Sirav Modi, and we are supplying the goods in US. So I have a shop in US and I am supplying goods there. Will that be liable to GST in India? No. Are the goods coming into India? No. So then it is not liable. Okay. But in income tax there is a concept of residential status. If Farooq Haq is a resident of India, then my foreign incomes are also taxable in India, right? So that is an income tax, but not in GST. In GST, if that taxable event supply doesn't have a relationship with India, it is not liable to GST. So even though Farooq Haq is a resident of India, I am the owner of shop in US and the sale is taking place in US, it is not liable to Indian GST. Okay. So that's also interesting one. Point number 7. Then supply of warehoused goods, this is under Customs Act, to another person before clearance for home consumption. Now this you have studied in customs, that we can import the goods and after importation we can store them in a warehouse, right? And while in the warehouse, if I supply them, how do I supply them? By transferring document of title, the bill of lading. I can sell off my bill of lading to anyone. Supply the goods. That supply will not be liable to GST because that is done before the goods enter the landmass of India, before crossing the custom frontiers, before the custom duty is paid, yani ki before the goods are cleared for home consumption. So if I sell off the warehouse goods which are lying in the customs warehouse before clearance for home consumption by selling the document of title, that will not be liable to GST. And supply of goods by the consignee to any other person by endorsement of documents of title to the goods after the goods have been dispatched from the port of origin located outside India but before clearance for home consumption. This is called as the high sea sales. High sea sales. That is before the goods enter the landmass, the same thing. So if I tell you both the things, then let me explain that this is the port and then this is the warehouse. So first thing is that if the goods are here in the ship itself, okay, or they might have landed on the port. They may be on the ship or they may be landed on the port, but they are not cleared for home consumption. So if I sell them here while they are already on board the ship or lying at the customs port but before clearance, if I sell it here, then it is not a supply. Or if the goods have been transferred to the warehouse and they are lying in the warehouse, and if we sell it here, still it is not a supply. Okay. But if the goods are cleared for home consumption from the port or from the warehouse, cleared for home consumption, if they are cleared and after clearing if they are sold, then yes, it is a supply. Understood? So after clearance if they are sold, then it is a supply, but before clearance if they are sold, then it is not supply. Understood? Simple. So all these points are there, 8 points which are not considered as supply. Neither supply of goods nor supply of service, means not liable to GST, no levy of GST. And apart from that, to be notified point is also there. Such activities or transactions undertaken by the central or state government or local authority in which they are engaged as public authorities. I gave you the examples of that in section 7 itself. Public authorities as may be notified by the government, like police and so on and so forth, on the recommendations of the council. So all these points are there, right? and then a simple flow chart is given regarding taxability, means whether something is to be called a supply or not. So you have to just keep answering yes and no, and you will find your answers. Like the kite is a question. Is there an actual supply? Answer may be yes. If yes, then you ask, is it of goods? If yes, is it for consideration? If yes, consideration is there, then ask me, is it in the course or furtherance of business? Make it or furtherance of business. If the answer is yes, then is the activity covered by Schedule 3 or is exempt? If the answer is yes, then it is not taxable because it is exempt. If no, means all the conditions are satisfied and it is not exempt or not covered by Schedule 3, then is it by government or local authority as notified by the government, that is public authorities? If yes, then again they are not taxable, but if no, then they are taxable, means all the conditions are satisfied. So this is straight down. Now let's come back up and say actual supply. Is it yes? If the answer is no, there is no actual supply, then you say that is there an agreement to supply? If the answer is yes, then again follow the same questioning step one by one. But if the answer is no to this also, actual supply, no. Is there an agreement to supply? No. If both the things are not there, then it is not taxable because there is no supply. Or if the question is that is it of goods? If the answer is no, then you call is it service? If yes, then follow the same sequence of questions. If no, means there is no goods and no service, then again it is not taxable. If it is neither goods nor service, not taxable. Or if the goods or service is there, then the next question is it for consideration? If the answer is no, then is it covered by Schedule 1, that is the exceptions, that even if there is no consideration they can still be taxable? If the answer is yes, then again follow the same sequence of questions. If the answer is no, means there is no consideration and they are not covered by Schedule 1 also, then it is not taxable. Or is it in the course of furtherance of business? If the answer is no, then there is one exception, that is import of service. If that is the case, then go back and make it taxable, otherwise not taxable. Or if consideration and furtherance of business both are there or the exceptions are there, then these two questions, is it exempt or covered by Schedule 3? If yes, then not taxable. Or if it's a sovereign function of the government, then not taxable, otherwise taxable. Right? So go through all these permutations and combinations at least 3-4 times and you will remember a lot of things. Great. So that was section 7 that we saw in full detail with Schedule 1, Schedule 2 and Schedule 3. Very interesting one, and one question you can expect on this definitely of around 4 to 5 marks, or it can come in those short MCQ based questions also. So go through it in very detailed manner. Okay, good.